Hello, this is Antonio Gangale. Today I'm going to discuss the August 6 bicycle crash and the subsequent arrest for OMVI. This matter had been reported on by the local radio station WJR. It ran most of the morning. Additionally, the Times Reporter, it's a local paper, ran the initial story and subsequent related stories. So there was 4 articles regarding it. The arresting officers was Mike Roden and Robert Everett. There was an 8-hour hold in Tuscarawas County Jail. Additionally, there was a sunshine request, and there's an affidavit by the chief of police. All of the documents that were presented to me on the August 6th matter that day, which were carbon copies, those will be changed and altered. So from the original, or what we construe as the original, or so the court documents and do not correspond to mine, is what I'm trying to get at. The prosecutor was Christine Weimer. She handled several cases. This related matter also yielded a driving under suspension, and so there was issues regarding that. The arrest was for OMVI. Many will see that there's issues that it's defective. There was considerable issues that the rules of criminal procedure from the New Philadelphia court were not done or skewed, and created a lot of legal issues regarding that. Also, the prosecutor withheld throughout the propensity that the citations were changed. So I had discovered that like 11 months, I believe, into these proceedings, and so there were multiple times at the court regarding these matters or related matters, and it was never informed of these changes and things. The judges in the municipal court regarding this case, Michael Carmella was the initial appearance judge that had defendants pleading not guilty go in the hall. I want to note that he was an ex-attorney that I had fired. So Mary Wade Space, there was the issue of suppression and whatnot. She handled that, and the driving under suspension and other cases. There's Ohio rules of criminal procedure, Ohio revised code statutes, as well as rules of procedure 5 and 15. Those are mandatory on the court. That I intentionally did not waive my right to the speedy trial, and I believe that there's issues of involuntary requiring to either waive for the speedy trial or the suppression of evidence. During that process, there was a conviction of a driving under suspension using the ALS for evidence of that. So it would appear that she was hedged in the hearing even before that. So there was multiple things with the judge. Of a visiting judge, William Todia, came in. Mary Wade Space recused. William Todia was a visiting judge. I believe there's some issues there we'll get into. Magistrate, it appears, Paul Gordon filed things within there after. There was a recusal from the local judges. It appears, I believe Todia passed during these proceedings or after the appeal or whatnot. So I believe another judge was appointed. There was some related cases with the driving under suspension, the ALS appeal or whatnot, or privileges and whatnot. So there was Judge Green in that case. And there was on September 14th, when we discovered the tampering and things, the clerks refused to file some petitions that I had brought when I discovered it. So there was some, I believe, legal issues regarding willfully depriving the right to file and First Amendment rights. There were 4 counsels in this matter. Gary Gregg was the first counsel. I believe that there's some serious issues with regarding the 35 days. Might as well kind of inform the rules of criminal procedure require, or it appears that your right to counsel at the initial appearance. They have people pleading not guilty go in the hall and sign your own cognizance, and counsel is later. The problem with that is if you only have 35 days to file motions and whatnot, and there's delays in counsel or up until that time, is there due process and equal protection issues of providing them the same allotted time to file these motions. So if the courts are using those as wanting extensions or construing them as waivers, which you'll see, or wanting waivers for them to file, there would be serious issues of willfully depriving or causing the deprived rights or privileges protected under the Constitution. They're not following mandated laws, and they're sworn oaths to faithfully and impartially apply the law. So there's serious legal issues within this case. As a not only just it being defective and all the tampering. Ron Collins was then appointed. There was some serious conflicts of interest with Ron. He actually was the prosecuting attorney in a matter in the county court, as well as I believe he was being prosecuted for domestic violence. So there was Ryan Steyer was the third counsel. There appears to be some issues of conflicts of interest regarding that appointment. Ryan Steyer had worked with the same offices of Gary Gregg. So there was some there, as well as his offices, I believe, share offices with another counsel. On appeal, Michael Puterball was appointed on appeal. It appears he's friends with the person overseeing the prosecution, and the person overseeing the prosecution is married to the judge. Additionally, he will be the arresting officer's counsel in a steroid case, which he was indicted on. The city of New Philadelphia, I had a meeting with Michael Johnson, so he was aware of the things that were discovered and conduct that was happening within the municipal court. The city of Dover, there was the law director, Tom Watson, who oversaw the prosecution. He passed in September 17th. His replacement was Zachary Space, who was the judge's husband. So there appears to be some possible issues of how that appointment occurred, if ethics, if you are allowed to take gifts or whatnot, or spouses are not encouraged to take things of value or whatnot. So there may be some legal issues regarding that appointment, as well as overseeing the prosecution, in which your wife had made multiple rulings and there were many issues in the case. Also, I failed to mention the arresting officer, I believe, worked for the municipal court earlier, a year or so earlier, as a probation officer or something of that, or maybe bailiff, I'm not quite certain. So there would have been issues of the judge having a conflict of interest or whatnot, or failing to disclose some of that. And she had determined the causation of crash. There was issues that there was no due process in examining that. So there were a lot of legal issues, and there was appearing to be a lot of conflicts of interest. There had been a discussion with the mayor of Dover after the driving under suspension. City council members, I believe, were the ones that did the appointment of Judge Mary Wade Space's husband. There might be some issues there. The custodial records for Dover Police Department, I had gone to the police station multiple times requesting information or documents regarding this, and they had been withheld or deprived on countless times. It was only after the the Sunshine lawsuit where we discovered was obtained a lot of information, and that Sunshine case happened after the appellate briefs were filed. So there was issues there. There was Patrolman Morrison that handled the driving under suspension. So that originated out of Dover, the ALS. So there's potential issues regarding that. During this process, about 11 months into it, where things were just countless things were, I filed an action in the Northern District Court of Ohio. It will later be dismissed in the opinion here. Now, this dismissal occurred before discovering of the tampering, but there were still issues of probable cause determination, the speedy trial, the crash, and things. And had there been discovery in the case, I believe this would have came out much earlier. In the opinion of that court, it too, that the arrest was for operating a motor vehicle under the influence. So I was not a motor vehicle. The Ohio Revised Code defines motor vehicle as any vehicle propelled or drawn by power other than muscular power. So it appears that it was defect, and it would appear that there would be no way to obtain a valid conviction. So I'm not sure why the federal court dismissed the action. Further, I'll mention the Northern District Court was the same court that handled Union, in which I was discovering a lot of legal issues regarding what transpired in Union. So there would be major issues of possible impartiality with that court. As I mentioned, September 14th is when I discovered the issues of the tampering or the changing of the citation in the ALS. This was reported to the Tuscarawas County prosecutor, or I had discussions with that office. I also had visited the county sheriff on these matters. When there was a refusal to file the petitions on October 17th, I filed petitions with the Ohio Supreme Court, the governor of Ohio, the law director of New Philly, and the mayor of Dover. There had been a stay when the recusal of Mary Wade Space occurred for the appointment of the visiting judge. That stay had lasted, I believe, 4 to 6 months. During this period, I believe I had driving privileges for 1 month out of the 24 months, approximately 18 or 24 months. So there was a lot of financial distress and issues of these matters, and also it was publicly being reported misinformation. So the ridicule and things, and the rights of travel, all those things were very burdensome. When I discovered most of these problems with the arrest, again, was for OMVI. There was issues of just multiple things in the case I'll get into. The civil rights actions are quite complicated, and the statute of limitations on certain things toll at different times. So I believe, if I'm correct, false arrest, excessive force, and things toll at different times. So there's a Heck versus Humphreys decision that kind of, I believe, gives more understanding of that. So these, with the time that had been going on, I was approaching, I believe, nearly the 2 years. So I had filed with the county court that has co-concurrent jurisdiction a lawsuit. What was even more complicated is that there was the crash. There was no due process, and the judge ruled. So there was issues if that was within the criminal case, and if there was counsel being represented in that matter. Additionally, I discovered during this process this administrative license suspension is a civil action. So the night of the incident, there was an OMVI charge and apparently this administrative license suspension. And so that appears to be a civil action, and that is commenced by the law enforcement officers, which are armed men making judgments while I was bleeding. So there was considerable issues and legal issues of all that matter. And additionally, there was the speedy trial issue and the rules of procedure, and if they are immunized when they are not providing the initial appearance. So in this act, and let me further mention that the administrative license suspension appeared to be tampered with as well. I still have no idea who tampered that. I'm not certain, because there was the driving under suspension, if the Ohio Bureau of Motor Vehicles regarding that case filled it in or when it was received. However, we'll get into the issues of whoever was in the chain of custody of that document, because the times that were filled in, it had to be someone with knowledge of the BAC, and that was being withheld from discovery. So only it appears that the Dover Police Department had that knowledge. So I don't know if the Ohio Bureau of Motor Vehicles had called or how that was filled in. So, and the Ohio Bureau of Motor Vehicles is a state agency. So there was a lot of, I believe, willful conduct and whatnot. So I brought litigation with the Ohio Bureau of Motor Vehicles and the officers in the Tuscarawas County, as well as the court, municipal court. Through this process, before filing in the municipal court, I filed a petition, I don't know if I had mentioned this, in a second action in the Northern District Court of Ohio. And that action, I petitioned. The First Amendment to the U.S. Constitution provides the right to petition for redress of grievances. Civil rights action is it's Section 1983, so it's derived through Congress. So the First Amendment, Congress shall make no law establishing the rights within the First Amendment. So I used the petition. In that case, raised the issue of the issues of if it was a biased and not a fair and impartial venue. During this process I had discovered more information regarding the union, and there would raise issues that there was violation of due process, equal protection of laws, Eighth Amendment issues of cruel and unusual punishment. So I raised issues of bias and whatnot, and I believe the court, or the judge, so permanently barred me access to the courts, which raises a whole larger issue of violation of the First Amendment. And that was without due process, a right to be heard. So there's considerable legal issues that had resulted from that. Throughout this I had contacted numerous attorneys and legal assistants, all that, to attempt to assist. So that's the rundown of individuals or entities that knew or had knowledge of what was transpiring here. I'll give you a little further background. So August 6th is the date of John Meyer's death. He was a good friend of mine. People had asked me or had commented that I should write a book about what transpired at Union. I started doing a very rough draft of a book. And for those that know some things about Union, none of it, the order just does not make any sense. So anyway, I was kind of debating if I was going to write the book or not. And this also going on is there was an arbitration case with a broker, and there's some numerous legal issues regarding this matter. So that was going on. So I had there was a significant question of going to be the outcome of the case. In the same time, I was in the process of patenting a projectile. So I believe at this point, the patent had been issued, and I had paid the fees, but it was not being issued at the time. So I was in the process of starting a business. Wasn't sure if I was going to take the licensing route, try to get it licensed, or going to start manufacturing and all that. And in the manufacturing, I had to worry about the packaging, the marketing, the components, the materials, and all that. And all these things trying to come together. I was fearing that I financially have all the resources I want to really launch the product and get it out there, and the time restraints and whatnot. So the bullet also had a aspect of armor piercing. So I was debating if I was going to hold off this year and do a heavy launch next year into the market. And so I was attempting to get this armor piercing aspect of it in production. And there had been that northern LA shootout bank robbery where the law enforcement were, I believe, shooting at these individuals, but they had armor on. So anyway, law vehicles, some of them carry shotguns and whatnot. So I was a piece of equipment that they already exist. So if I could get that market, I was hoping I could possibly generate revenue off season and go that route. That route, however, there was a federal firearms licensing of destructive devices, which I think came to like $9,530 or something of that. And I was debating, or when I was researching it, as if this is a right or a federally protected right, why do I need to be paying fees, and are they excessive and whatnot? So there's the United States versus Miller Supreme Court opinion, where it explains what the Second Amendment was intended for. And in this opinion, it states, this implied the general obligation of all male adults possess arms, and certain exceptions to cooperate in work of the defense. So the Second Amendment was intended to have states and people were required, implied the possession of arms and ammunition, and to be trained for this. And also there was penalty for delinquency of this. So there was considerable issues that the Second Amendment is not being applied as it is intended. So here, the obvious purpose to secure the continued and render the possible effectiveness of such force as the declaration and guarantee the Second Amendment were made. It must be interpreted and applied with that end in view. Anyway, I had contacted several attorneys to address that question, and the fees of those were exceeding the cost of what the filing was. So anyway, I was debating if I was going to do that or what approach to the business I was going to take. So anyway, those were the kind of things that were going on, and my brother had came into town, and several people had came up, and I just started hanging out and had a few beers with them. They wanted to go to a bar and convinced me to go, and we hung out I think a couple hours at the bar. I believe I had one or two there. Really wasn't in the mood to be partying and whatnot. We came home with a few of the people for a little longer. Toward the end of the evening, I had so many things going on in my head, I knew I wasn't able to sleep. I had changed my clothes, heading down the stairs, and actually I ran into or met up with Donnie at the top of the staircase. Asked me what I was doing. I told him I was going for a bike ride, and he even mentioned him wanting to come along or whatever, and I just wasn't in the mood to hang out kind of thing, so I just needed to think some things through, and so that I had gone. There's a Supreme Court in a case. They stated, "We know, however, from experience that sleepless people often walk at night, perhaps hopeful that sleep-induced relaxation will result." So, rather than walking, I took a bike ride. Kind of did a lap, kind of through New Philly area, and I went through Dover, went to the north end where the ball diamonds were, did a loop in that area, and I was heading back home, and I had lived on the corner of Iron Reeves, and as a kid, and throughout most there's that road, Oxford Street, that kind of is a shortcut through the through the industrial kind of area. So apparently through my ride coming down off the bridge nearing Wilmar's, I had passed a vehicle, and it's late at night and you don't stare into the headlights and whatnot, and I was in thought of things, so really didn't pay attention to who I was passing or what exactly the vehicle was. And I was just coming off the hill, so it was, a decent speed as it is. So anyway, I turned into Oxford Street, heading toward the old house. So anyway, I had gone on. I was on Oxford Street, just onto Oxford, and this vehicle is fast approaching. And it's not parallel with me, it's coming at an angle, and it's increasingly coming at me, and I'm veering tighter to the curb, further and further, trying to avoid or trying to figure out what the hell this vehicle's doing. The CVS was under construction at that time, so I don't know if I have... Yeah, so you'll see that there's a retaining wall there now, so I don't have the pictures exactly of how the landscape was, or the So anyway, I'm trying to get off to the side of the road, and this vehicle is approaching, and I don't know exactly how in the hell it happened. Either the bike locking up, or the tire turn, or whatnot, or grab something. I don't know, but I fly over the handlebars, and kind of before I really know what's going on, there was two individuals there. Those individuals will be later to be determined it was Mike Roden and Robert Everett. So here's some of the transcripts of things. I'll just kind of go through to kind of... So we'll later discover that the site, the police log has it at 4:56, and that kind of be important. We'll find later. Did you have your window down? So there really doesn't affirm that the window was down. Okay, after you yelled a second time, he still did not stop. What did you do? Well, to be truthful, I was upset, and that he was either ignoring me or he did not hear me. So I turned the car around. I was going to tell him again. Did he ever acknowledge you? No. Did he look in your direction? I don't believe so. Did he wave to you? No. Okay, what was the purpose of the pursuit? Did you have the radio communication with the base? Yes. During the period of time, did you see him commit any traffic offense of any type on Oxford? No. Here, probably the distance, 3 or 4 feet. Did you have the occasion to point to him, or to verbally speak to him? No. I yelled to him. At that point, he must have hit the brakes because he went over the handlebars of the bike. The bike stopped, and he went over the handlebars, took a tumble, and came to... I just saw him fly over the handlebars and back wheel going up with it. So it was basically a complete topple. Were you able to see how he had landed or anything of that nature? No, I didn't. Because I was concerned I didn't want to run over the guy. I mean, we're talking a short distance. So for those, I was clipping along. You would think so for those, I've been in several bike crashes in my life that were fairly significant, and this was a fairly significant crash. As a youth, the area boys, we would race down this hill, and I had crashed once on this hill, and by the time I had got home, I had blood all the way to my kneecaps, and my mother nearly passed out when she saw me. Another time I was playing bike tag and hit some pavement that was just asphalted, and I actually cracked my 2 front teeth and had to go to the dentist to remove the tar that was embedded in them. So I've been in fairly significant crashes, and this crash was significant. I mean, I definitely had my bell rung. There was definite issues of severe concussion. I believe at that point I called the station. I was going to go to be with the bike on Oxford, threw the radio down and jumped out of the car. So we know what the times of this event here. Then I asked him to stand, or after I asked for a Denver, he told me his name. Okay, he started to get up once. Once he was on his feet, he fell back down. What do you mean, fell back down? He just fell back down. His legs buckled, and he fell down. Fell over. He looked like he was going to fall again. He was just standing there, swaying, wobbling. I asked him if he was going to fall. you still in the presence of the defendant? Yes, I was standing there right there. And to be honest with you, I have no idea why Captain Everett started field sobriety. So my recollection of events is when Captain Everett came, he had asked me what I was doing. I said I was exercising. Then he had something like, well, what are you exercising at 4:30 in the morning? And I believe I had mentioned that I was thinking. And then he went on to, what were you thinking about? So so for those, so as I had mentioned before, these events, the prosecutor and the police department did not release the police log or the tapes or whatnot to exactly know time periods and whatnot. So you'll see that it's showing that this occurred at 4:56 on Oxford with bike, 4:57 with the bike. So it appears to be 1 minute after a serious bike crash. He just stand there looking at us. Captain then asked him if he to perform a finger dexterity test. So I just crashed a bike. There's issues of severe concussion. I landed catching myself with my hands, and they wanted me to do a finger dexterity test. We're talking moments after a crash. This total encounter appears to last 1 minute from the bike to the arrest. So is this reasonable questioning? Is it reasonable to do the finger to know, a finger dexterity test with the injured part of your body? Is any of this reasonable? So I believe I mentioned that I'd rather not. And that's when I was arrested. And then anyway, here, I cuffed him here. I believe Everett said he was going to take him to the station. I'll take the bike, I'll take the bike, and I believe Everett put the bike. So you'll look here. I radioed in, and then en route to station with the prisoner for a BAC test. After you finally got Mr. Gangale standing, was he ever stable on his feet? Not the entire time we were there. How long were you there? 10 minutes? Well, Miss Weimer, if she had examined the document, she would realize that it's 1 minute, or approximately a minute. So do you think that this was a reasonable thing after a severe crash of issues of concussion? So was this reasonable under the Fourth Amendment? But we'll get into some of that. So again, you'll see. So what's interesting too is, so with the bike in Dover Station at 5:01. So here's the report, incident report, or excuse me, the supplemental report. Here, I went on to explain to him he was under arrest for operating a motor vehicle while under the influence of an alcohol. So while we're at the police station, here, that's when I had enough. I asked him to turn around and place his hands behind his back. He was under arrest. Here, at what point we're okay, what happened at the police department? At this point, we were where his Miranda rights read to him. I believe it was at the station, okay, in the BAC room, yes. I don't know if Miranda were read. I don't recall them. They didn't produce a form or whatnot when even at the Sunshine request. Okay, did he at some point tell you to speak with an attorney? Yes. Here, Captain Everett's deal and BAC machine, it's the one, he's handling it. Threw him his phone book. He said there, here, call whoever you want. Here's where, okay, so here, just after just as Officer or Everett started doing the after the defendant signed his sheet, he immediately said he wants an attorney. So for those, I want people to understand signature. So just after signing this, you'll see right underneath it says signature of driver. And what's directly below in parentheses? OMVI rest only. Now, I recalled that he had arrested me for OMVI. Here, it's again OMVI. I was on a bicycle. I'm not a motor vehicle. I don't need a driver's license to operate a bicycle. So I wanted to speak with an attorney of this issue. Also, this guy ran me off the road. Or my contention is he forced me off the road. He's the one that caused the crash. I don't know why. What is going on is I was minding my own business, and this officer just comes out of nowhere and is running me off. Like, what did I do for the pursuit or anything? So I definitely wanted to speak with the attorney regarding all these matters. Oh, so here you'll see the ALS, that it's empty, date of refusal. So anyway, so on Miranda, so what's interesting here, explain the phrase, you have the right to an attorney. If you cannot afford an attorney, one will be provided for you. That means a person has the right to an attorney. If they request an attorney, all question has to stop until they have an attorney. So here, what does Captain Everett do? Going to take a test. He refused the test. Again, he asked again for an attorney. So if you ask for an attorney, is the questioning and stuff supposed to stop until you have one present or one is provided? Talk with one. So is Mr. Everett continuing to proceed where the law requires that counsel be there, or if he requests one? Now again, and I don't realize even until after that these are actually civil actions commenced on the spot by officer while you're bleeding. So these are actually appeared to be construed as civil proceedings, and you don't have someone like so. Are there issues that I did not legally refuse? Is he proceeded and took it as refusal and ignored the rights of counsel? So let me get a little further here. So here again, this was in the sunshine request even after the appeal. So we know that it appears that the arrival at the station at 5:01. So this test, so getting there and sitting down, I don't know exactly when the entry into the room and things, but here the blank test is 5:10, and here the subject's refusal he shows at 5:13. So try to, here, date, start, observe, time. Is there, and here let me kind of show you. The mayor's receipt, February 15, 2002. Let's go a little. Observe the subject for 20 minutes prior to testing to prevent oral intake. What time was the event? It appeared to be 4:56, and 4:57 was with the bike. 5:02. Police department. I don't know if that's a riot. So then what was the time of starting this or observing time? What was the start observed time? So is Captain Everett, are these checks, are these accurate or correct? And did I actually refuse, or did he proceed without counsel? A trial conducted within the walls of a prison is a denial of due process. So is the administrative license suspension, is there serious legal issues regarding that of an armed officer making judgments while you're bleeding? And again, this is the copy where you see it's not filled in of the refusal. And now this is the document of the courts, and we see that it's filled in. And the writing looks somewhat different than the person. I don't know if you, the 8s look, and his 0s are with slashes, so it appears that someone else is filling in this time here. This is a carbon copy notarized document. And then who would know that it's at 5:13? Again, the only people, who are the people that have access to this data? And if it's someone from the Ohio Bureau of Motor Vehicles, how did they correspond to obtain this information? And is that multiple jurisdictions? Is that through communication lines? And then in the driving under suspension case, was it mailed? How was it transported to present this in that case? So there was multiple legal issues, I believe. And here the arraignment. Again, this is an ex-attorney. You'll see he's attorney in this case. Duty of a law enforcement officer who issues a citation complete to sign, serve the copy of on the defendant without unnecessary delay, file with the court of record. If the issuing officer personally served of a completed ticket on the defendant, the issuing shall note the date of personal service on the ticket. So I have a citation sworn under falsification and perjury, and mine is different. And here the shall consist of 4 sheets padded together, bound on the top and the bottom, or the bottom. Each sheet. So now, Rule 8, arraignment. Arraignment shall be conducted in open court, shall consist of reading the complaint to the defendant, stating the substance of the charge, call on him to plead. Defendant shall be given a copy of the complaint and shall acknowledge receipt thereof before being called upon to plea. So, did that occur? The judge shall cause him to be informed and shall determine the defendant knows and understands. So, they have people pleading not guilty go on the hall and sign their own recognizance. So, does it create serious legal issues? Here, defendant, an objection shall be raised before plea. So, is the charge defective? Are there countless legal issues within this case? A criminal defends initial appearance before a magistrate where he learns the charge against him and his liberty is subject to restriction marks the initiation of adverse judicial proceedings that trigger the attachment of the Sixth Amendment right to counsel. Motions before plea. So, on this citation that was served on me, was it at 446 or was it at 456? So, is there issues of that being wrong? Is OMVI, is it defective? Are there issues, the definition of influence? Is that constitutionally vague? The issue of refusal, was it actually a refusal? The crash, stating that there's non-injury. Crash report number 99352. Accompany criminal charges not filled in. Here, summons served personally on defendant 8/6. issuing charge in law enforcement states under the penalty of perjury and falsification, and he has read the above complaint, and it is true. Defendant's copy. So here, did you take the occasion to view the area where he had wrecked his bike? Later I did. So it appears that he conducted an examination of it. There is supposed to be, it appears that there is a crash report, yet it appears, so after examining things, no longer a crash report. Yet he did examine it. What does that imply? Here, was there further, are there legal issues of not providing counsel that there would have been evidence within the Shell Mart or whatever videos or whatever the possible understanding of what transpired? So here, this is the agency record. We see the accompanying now it's filled in. We see this crash report scribbled out now that there is an injury. And recall that I had been taken to the county sheriffs, so they would have had observation of knowing what injuries and the aid that was provided there during that period. Here, are there issues with the charge being defective? So we see. So, has the citation been changed or altered with? Here's roid rage. Roid rage can be defined as a condition in which a person tends to act aggressively after taking unusual doses of anabolic steroids. According to the article that appeared in the FBI Law Enforcement Bulletin, anabolic steroid abuse by law enforcement is a serious problem that merits greater awareness by departments across the country. Here, there is a great potential for an officer abused to physically mistreat people. Anabolic Steroids Act. Here, both the physical and emotional effects of the drug endangers the public and exposes drug-taking officers to serious legal risks resulting from their dangerous drug-induced behaviors. So was there ever an investigation of the crash, and was there ever examination of the officer if he was under the influence of anything of drugs or alcohol or drugs of abuse? As a part of the defendant's due process right to fair trial, prosecutors are under the obligation to disclose to the defendant any favorable evidence of material of guilt or punishment for cases or remedies of Brady violation. Motor vehicle means any vehicle propelled by power other than muscular power. Arrest, yes. Description, OMVI arrest. Charge, operating motor vehicle under the influence. Fourteenth Amendment, no state shall deny any person within its jurisdiction equal protection of laws. Disclosure of evidence by the prosecuting attorney. So on the arraignment hearing, here, general prior representation of a party who is now a judge is a disqualifying factor. Ohio Revised Code 2937.02 to 2937.02 supersedes by Criminal Rule 5 and Criminal Rule 11, which are mandatory upon a trial court. The right to procedural due process is conferred not by legislative graces, but by constitutional guarantees. Coleman v. Alabama, the preliminary hearing is a critical stage in which the right to counsel applies. Traffic Rule 15, revised, repealed on October 1, 2006. authorizes contempt proceedings before the Supreme Court against any judge, clerk, or other persons who willfully fail to apply or adhere to Ohio traffic rules. County of Riverside's Mr. Langland, a person arrested without a warrant is entitled to prompt determination whether there was probable cause to arrest. Raised the question whether the exclusionary rule is applicable when there is a McClellan violation. The prosecutor assessment of probable cause standing on alone is insufficient to justify restraint of liberties pending trial. So was there a probable cause determination, and was it defected? How would it get past an initial appearance in this matter? And again, this was reported by WJER. Was there false light or misrepresentation of facts? So there's issues of being publicly scorned of this information. And the Times reporter, did they misrepresent the particular charge and whatnot? And then with no initial appearance, and was it on the officer's assessment? So as I mentioned, I had gone into federal court about 11 months into this proceeding. There had been multiple things, but you'll notice McClellan brought an action seeking injunctive declarative under Section 42 U.S. Code 1983. So he filed and then accepted a filing of a second amended complaint. So in my action, was there ever ability to amend the complaint? Was there ever an explanation of being heard in the action before its dismissal? So there was a lot of things, and on a writ of habeas corpus is your right to counsel for assistance in the preparation of that writ. So there were a lot of legal things, I think, in the federal action that I think justified that the injunction should have issued. Oh, and was there a neutral magistrate in the municipal? Here, providing probable cause determination within the framework as a general matter immunizes such jurisdiction. So, was there issue of the New Philadelphia court lacking jurisdiction? Were they immunized from that attack? Where rights secured by the Constitution are involved, there can be no rulemaking or legislation choosing between suppression and speedy trial. Here, defendant did not waive his right to the speedy trial. He intentionally did not do that. I filed a motion to suppress. Gary Gregg. Sorry, I filed a motion. The court. Motion for leave? Gary. Leave because it was the court. Out of time. Gary. Past the 35 days, right? Which isn't uncommon because a lot of the times we do not get the paperwork until the time is up, or at least we do not see the defendant until the time is up. So, is there a constitutional right to have counsel in the initial appearance? So if they're waiting until after, is the court tolling time of the 35 days at the initial appearance? Well, you don't have counsel there. So is there due process and equal protection the way the court is structuring these hearings? So are they serious, and do they know that this is occurring? So are these acts willful? Are they willful? 14th Amendment. No state shall deny any person within the jurisdiction equal protection of law. You know, I don't mean to hide it. I know some courts do that. Don't say they're doing it on the record. So does it appear that they're doing this systematically throughout the state of Ohio, of skewing these proceedings and not providing people the right to speedy trials? So does it appear to be systemic? I don't mind putting this on the record at all. So here's let's go a little further into the motion to suppress, oral hearing requested. So investigators lack probable cause to arrest the defendant for OMVI. So was I a motor vehicle? So in violation of 4th and 14th Amendment Constitution, Section 14, Article 1 of the Ohio Constitution, in addition to defendants moves to suppress any oral written statement made by defendant of the arresting officer, patrolman Mike Roman, and or the BAC operator, Captain Robert Everett, in violation of 5th and 6th Amendment to U.S. Constitution and Article 1, Section 10 of the Ohio Constitution. Here, within that motion, the defendant was arrested for OMVI. The officer later actually created a danger to the defendant. Are there issues that it's constitutionally vague, the term influence? Now so during this period, I get stopped for speeding, so I was arrested again in Dover. And in this matter, again, they go through the initial appearance, the same as having people pleading not guilty go in the hall and sign their own recognizance. This time, I wasn't going to allow counsel to waive my right to the speedy trial. So I had gone into the case, and I had mentioned to the court that we have a suppression of evidence filed in the OMVI case. So, and that material is what's being used in this case. Well, ultimately, I get convicted in the driving under suspension case, and this is before the hearing of the suppression. So for those individuals saying, well, the exclusionary rule is applied to not being used in criminal cases or whatnot, then you gotta ask yourself so what is the judge's, if I'm being found guilty using that evidence, what is the judge's intentions in the OMVI suppression hearing? So is it going to be a fair and impartial venue? Court. Is it a neutral court? And the prosecutor that was assigned in that trial, Gary had requested to be off the case, I get appointed Ron Collins, which happens to have prosecuted me in this case, and I believe was being prosecuted. So there was a suppression hearing. So during the hearing, only the officer Roden testified, so the person conducting the field sobriety, Robert Everett, didn't testify. And he's the one with the BAC machine, that the issues of counsel and whatnot. So here, did you notice any injuries or bleeding or anything? No. At no point did you notice any bleeding? No. So I knew that this was false, and I had gone to the county sheriffs for documents to see, because I knew that there was definitely injury, and the nurse or person on staff provided me things for it. And if you ask what was provided, was it little Band-Aids? What exactly aid was provided? And you'll know that it was gauze and tape. So for those saying, well, these are just minor nicks and whatever, there was injury. There was significant injury. Mitchum versus the exception to the Anti-Injunction Act. Title 9, Section 42 U.S. Code 1983, which also authorizes suits in equity to redress the deprivation under the color of a law of any rights, privileges, or immunity secured by the is within the exception to the federal anti-injunction statute. Here, Younger versus Harrison are not questioned. The district court is held to have erred in holding that the anti-injunction is absolute bar, isn't adjourning. So when I had gone into federal court, to seek injunctive relief. So after the suppression hearing, so there had been considerable delays in the suppression, the ruling on the suppression. And I had a meeting with Ron Collins, and I were in his office discussing, wondering what the delay is, and we had walked over to the courthouse and went up to see what the delays were in this case. So during that, I was in the court hallway, and in between cases, Ron had gone up and started talking with the judge. And there was some considerable time, and then he came back, asked me some questions, went back to the judge. I think he then went to the clerk's office and back. So this encounter, I believe, was approximately, I would say 40 minutes. I'm not certain of the time, but it was a significant period of time. And it was very odd, just how the questions asked and whatnot. And I had known that the judge was already hedged in the driving under suspension. I knew there was other things in procedures or whatever that I was. So I definitely felt it was not a fair and impartial court. There was the issues of the crash. There was just a lot of things of the tampering and whatnot. We were seeing things, but hadn't really discovered the majority of stuff. However, I definitely felt that the judge was going to attempt to do something very unusual or whatever, and I knew that I had a notion that the judge was going to not comply with things or attempt to make things fit that weren't fitting. Anyway, I had a notion that the judge was not going to be fair and impartial, and that's when I filed the injunction. So after I filed the injunction, and before the injunction was ruled on, now this is the judgment entry. This matter came before the court upon a motion to suppress filed on behalf of the defendant. The defendant moves the court to suppress any and all evidence pursuant to the stop of the defendant's bicycle for the reason that the stop was not based upon reasonable suspicion derived through objective articulable facts, and the investigating officer lacked probable cause to arrest the defendant for OMVI. Now, again, it's OMVI. Within that motion, further, it's stated here, the officer did not effectuate a stop. The officer admittedly was in short pursuit, but did not effectuate a stop. The court finds the defendant crashed his bike on his own, giving the officer cause to stop the cruiser and go to the defendant's aid. So here's where it gets in, is under the totality of the circumstances here presented, the court finds that the officer did gain probable cause to arrest the defendant for driving under the influence. So it appears the judge changed the particulars from OMVI to driving under the influence. Terry v. Ohio, it uses particular circumstances. The judge uses totality of circumstances, and also asserts that did not officiate a stop. The Fourth Amendment applies to stop and frisk procedures such as the following. When an officer accosts an individual and restrains his freedom to walk away, he is seized. That person is within the meaning of the Fourth Amendment. So, what does the judge mean by did not effectuate a stop? So I was even arrested, and this was within a minute. Here, the scope of the search strictly ties to justification of the circumstances which rendered the initiate permissible. So, what were the questions regarding, and what was the reason for the stop? So, are those questions supposed to be limited to what it was? So, what the hell is asking me what I'm thinking and what am I doing have anything to do pertaining to the stop? It is a serious intrusion upon the sanctity of a person, which may affect greatly indignity and arouses strong resentment. It is not to be undertaken lightly. Whether the officer's action was justified at its inception. So, was I being forced off the road? And what was the reason for the pursuit? The office may, in appropriate circumstance, in appropriate manner. How is that? It says that he was endangering me in this suppression. Remember, here, reasonable particular search in light of particular circumstances. The judge uses totality of circumstances. So is that even the judge's judgment entry? And then was there any accompanied charge? Did the officer conducting the sobriety in the BAC, did he testify? So there was, I believe, considerable legal issues of it was not. So did the judge, how did the judge make findings of the crash? Again, remember, there was OMVI. We can jump to the appeal. Again, the appellate attorney is apparently friends with the law director, Judge Space, is friends with the law director that was Zachary Space, which was married to the judge Mary Wade Space. And he's representing the arresting officer, or will be, in his steroid case. So are there issues? Anyway, what is the error? The trial court erred in overruling the appellate's motion to suppress evidence where the police officer lacked reasonable suspicion activity to warrant the stop, probable cause arrest the appellate for driving under the influence. What exactly was the motion to suppress? So is that even correct? So I'll start another tutorial. Thank you for your time.